Hi, I'm David Levy, a partner at Howie, Sachs and Henry, and I'm here today with my senior law clerk of over 20 years, Orit Winkler.
Hi, everybody.
Today, we're going to talk to you about best practices for the rehab community in handling accident benefits claims, some common challenges that we see arise, and our suggestions about how to deal with them. So, Orit, let's start rather than in a technical place, but in a personal one. What things can be done at the outset of a claim to help develop the right rapport with the insurance adjuster?
So, one of the first things that I like to do when I get a new file is I like to call the adjuster. I like to establish a personal relationship or rapport with them. I feel like it's a much better way to do things than by just sending an email. And once we establish a rapport and a relationship, I find that the adjuster is more likely to be helpful, to assist, and to approve treatment plans, quite frankly.
And I think we have to remember that there's unfortunately an inherent cynicism in the job of an insurance adjuster and everything that goes on. Developing that rapport early on, establishing connection, establishing some trust will go a long way towards helping you get the right results for your clients during the course of the file. Okay, let's move to something a little more technical. It's the tedious part of the job, sending invoices and getting paid. What are some best practices to help treatment providers get their invoices paid on time?
So, firstly, it's really important to bill once a month. We understand that HCI only allows you to bill once a month. And the reason for that is that you want to, A, make sure that your providers get paid in a timely fashion, and B, make sure that you're not behind on payments. And the issue is, I think, one of the biggest issues we have is especially when treatment plans are approved, we do not know if you're not getting paid. So if you have invoiced for treatment that your providers have provided and you're not getting paid because the treatment plan was approved, we have no way of knowing that you're not getting paid. So it's super important for you to notify us right away if the adjuster is behind on payment so that we can help get your providers paid.
Absolutely. And from the lawyer's perspective, if this doesn't happen in a timely fashion, it really puts us in a difficult spot as we approach the settlement phase of the case. If there are invoices that are outstanding, bills that haven't been paid, we don't have an accurate count of how much money has been spent and therefore what's remaining in any particular treatment basket. We're having accurate figures. And then often we have the problem of a case gets settled, invoices are forgotten. And then only after the fact, sometimes long after the fact, this comes to light, by which point the adjuster has closed their file, the client has been paid, the money has been dispersed, and however that issue is going to get resolved at that point, someone's going to be unhappy. So I can't emphasize enough what Orit said about getting your billings done on time, and certainly if there's something that's been approved but not paid, to get in touch with both the adjuster and the corresponding lawyer in a timely fashion.
Okay, so now it's your turn to be in a hot seat.
Okay.
What are the common things you see insurers push back on when treatment plans are submitted?
It's a great question. The short answer is things that are not in compliance with the SABs. Some specific examples will include trying to assign hourly rates beyond those that are contained in the schedules. One of the other things that we see routinely are transportation expenses. And as I'm sure you've all seen, this is an area of great concern to the insurance industry. For those of us who've done this for a long time, we know that transportation expenses used to be a lot more generous than they are now. But the SABs are what they are, and attempts to get transportation expenses paid when the SABs simply don't provide for them is usually not going to be met favorably. Sure, occasionally an adjuster will miss it or let it slide. And sometimes, to your point earlier, Orit, if you've developed the right rapport with an insurer and you talk about it in advance, there may be exceptional circumstances where these things can be approved. But generally speaking, asking for these things to be paid when they're simply not permitted by the SABs is likely to lead to a no. It's likely to lead to ill will. And it's likely to cost you the benefit of the doubt, the relationship, the rapport, the trust that you've spent all that time and energy building. And so our recommendation is simply not to do it. It's not worth it. and it probably is causing more harm than good. Thanks for watching. We hope you enjoyed. If you have questions about these or any other issues about accident benefits practice, please reach out to us. We're happy to talk.
Thank you.